If you inherited a house here in California and you're wondering whether you can just sell it, this video is for you. First, I'm sorry if you're watching this, you probably lost someone, and now on top of grieving, there's a house, a mountain of paperwork, and 100 questions nobody prepared you for. I'm Franco, a real estate agent here in LA County, and helping families through exactly this is what I do. So let's answer the big one. Can you sell an inherited house before probate is finished? The short answer, usually no, not right away, but there are some important exceptions, and once you understand how this works, it gets a whole lot less overwhelming. Stay with me because I'm going to walk you through it in an easy to understand way. No legal jargon, so you know exactly what to expect and what your next step should be. So can you sell before probate? When someone passes away and the house was in their name alone, nobody can legally sell it, not even the family, until a court gives one person that authority to act for the estate. That person is called the personal representative. And here's the part that surprised people. Being named in the will does not make you that person. You don't have legal power until a judge signs off and the court issues a document called letters. Until those letters are in your hand, you can't sign a listing agreement, you can't accept an offer, and you can't transfer title. I know that's frustrating when you just want this handled, but there's good news. You can use the waiting time to get ready, and not every situation requires full probate. Let me show you the exceptions next. Probate isn't always required, and this is where it pays to check before you assume the worst. First, if the home was held in a living trust with a successor trustee named, that trustee can usually sell without probate. So pull the deed and check how the title is held. Second, California changed the rules in 2025. Under a law called AB 2016, if the home was the person's primary residence and is worth $750,000 or less, the family may be able to transfer it through a simplified court petition instead of a full probate. That can save months. Whether you actually qualify depends on details only an attorney can confirm. That legal call isn't mine to make. My job is to spot it and get you to the right probate attorney early, so you don't waste time. If you're not sure how title is held, that's the very first thing that we figure out together. Let's talk timing, because this is where families get caught off guard. Even a simple no-drama probate in California usually takes 12 to 18 months from start to finish. Here's roughly how it flows. First, an attorney files a petition with the court. The hearing to appoint the personal representative is usually set about 5 to 8 weeks out, even after the judge approves it. The official letters can take another 2 to 4 weeks to actually be issued. So realistically, you're often looking at 3 to 4 months before you can even list a home. Then once the letters are issued, California requires a 4-month window for creditors to come forward. Now here's the relief. The house can absolutely be sold and escrow can close during that window. That waiting doesn't freeze everything. It just shapes the timeline, and knowing it up front means no nasty surprises down the road. So what do you actually need before the house can hit the market? 2 documents do the heavy lifting. The first is the order for probate. That's the judge's signed approval of the personal representative. The second is the letters, and this one's the golden ticket. The letters are what give your representative the legal power to sign the listing, open escrow, and sign on behalf of the estate. There's one more thing to look for on those documents, whether the court granted full authority or limited authority. Full authority lets the sale move much like a normal sale. Limited authority means the court has to confirm the sale, which adds steps and time. You don't have to memorize any of this, that's what I'm here for, but when we talk, having copies of these documents ready lets us move fast the moment you're clear to sell. Let me save you from the 5 most common mistakes I see executors make. 1, listing the house before the letters are issued. It feels productive, but it can blow up a deal and cost you a buyer. The second, assuming the sale money goes straight to the heirs at closing. It doesn't. Proceeds sit in the estate account until the court approves the final distribution, often months later. 3, assuming a trust automatically means you're covered. Sometimes a home was meant to be in the trust but got left out during a refinance. Fixable, but only an attorney can sort it out. 4, grabbing the first lowball cash offer because you think probate means selling cheap. It doesn't. As a executor, you have a duty to get fair value for the heirs, and there's usually time to market it right. And 5, waiting too long to get help when a reverse mortgage or foreclosure clock is ticking. In those cases, every week counts. So here's your simple next step. Before you call 10 agents or list anything, do 2 things. First, find out how a title was held in the person's name in a trust or jointly. Second, talk to a probate attorney early so the court process gets moving. Those two moves alone put you ahead of most families. And if you're here in LA County, that's exactly what I do. Reach out and I'll walk you through your specific situation. Point you to a good attorney if you need one, and help you sell when the time is right. No pressure, no pitch. And subscribe for more guidance on selling inherited property in California.